This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we speak about unjust enrichment and what happens when an insurer claims it overpaid a claim, and why policy terms control the right to return of overpayments. And especially why an insurer that claims it paid more than it owed admits to having an incompetent claim staff, all of which brings about litigation. And that is a case entitled Scott A. Saveraid Trust versus QBE Specialty Insurance Company, filed in the United States District Court for the Middle District of Florida on or about November 7, 2025. The plaintiff, Scott A. Saveraid Trust, owns real property in Fort Myers Beach, Florida. The trust purchased a homeowners insurance policy from defendant QBE Specialty Insurance Company. In September of 2022, the property sustained damage from Hurricane Ian, a covered peril under the policy. The trust filed a claim with QBE, which investigated and paid $307,622.32 for dwelling coverage and $20,600 for loss of use. QBE alleges the damage was primarily water-related, that is, flood damage, which is excluded under the policy, and that it, quote, mistakenly opened coverage, close quote, leading to these payments. The trust contends QBE underpaid and owes additional benefits under the policy. Two exactly opposite positions. The trust filed suit against QBE for breach of contract seeking additional policy benefits, and QBE filed a two-count counterclaim. Count 1 being declaratory judgment under 28 U.S.C. Section 2201, seeking a declaration that the VPL does not apply to the policy. That is, QBE is not obligated to pay the full policy limits for a total loss. And count 2, unjust enrichment, seeking repayment of the $328,222.32 allegedly overpaid to the trust. The issues were, 1, does QBE's request for a declaration that the VPL, that's valued policy statute, does not apply to the policy's state a valid claim under 28 U.S.C. Section 2201 or is duplicative of the trust's breach of contract claim, and QBE's affirmative defenses are merely a factual dispute unsuitable to declaratory relief, and 2, can QBE pursue an equitable claim for recovery of alleged overpayments under the policy when an express insurance contract governs the parties' relationships and the subject matter of the payments. With regard to the motion to dismiss, count 1 declaratory judgment was denied. The claim survives as it presents a valid actual controversy, is not impermissibly duplicative, and involves a legal, not purely factual issue. Count 2, unjust enrichment, was granted with prejudice. The claim is barred under Florida law because the alleged overpayments fall within the subject matter of the express insurance contract. The claim satisfies 28 U.S.C. Section 2201 and Article 3 because there is a substantial immediate controversy over the VPL's applicability to the policy, adverse legal interest between the parties, or whether QBE must pay the full policy limit for a total loss. This is a legal interpretation, not a mere factual allocation dispute as argued by the trust. even if redundant. Redundancy alone does not warrant dismissal. Under Rule 12b-6, which tests validity, not necessity, substantively, the claims differ. The trust breach claim seeks benefits pursuant to the terms of the policy itself, while the declaratory claim addresses whether the VPL independently mandates full payment. Courts permit declaratory claims alongside overlapping defendants because defenses are negative, relieving liability, while declaratory relief is affirmative, seeking a binding interpretation. Dismissing at the pleading stage is premature, as overlap may not moot the claim and litigation costs are minimal. The court exercises discretion, therefore, to retain it. Unjust enrichment claims require 1. Conferral of a benefit, 2. Defendant's knowledge, 3. Acceptance or retention, and 4. Inequity in retention without payment. However, it is unavailable where an express contract covers the same subject matter. Here, the policy governs all claims, payments, and coverage disputes, including overpayments QBE made in response to the trust claim. The 11th Circuit's recent decision in Moni Life Insurance versus Pettis is dispositive to the district court. There, an insurer's unjust enrichment claim for overpayments failed because the payments, even if mistaken or unauthorized, arose from the insured's claim under the contract's terms. The court held such claims fall squarely within the ambit of the express contract, regardless of policy provisions for recovery or the reason for overpayment, such as mistake or misrepresentation. Payments were made pursuant to contractual obligations, not outside the policy's scope. QBE's claim that overpayments are distinct subject matter was unpersuasive to the court, and especially post the Moni decision. Moni applies broadly, not limited to misrepresentation cases, and dismissal with prejudice as amendment would be futile. The ruling reinforces the 11th Circuit's strict bar on quasi-contract claims in insurer-insured disputes, prioritizing contract law over equity for payment recoveries. It highlights the court's reluctance to dismiss declaratory claims early, especially in insurance cases involving statutory interpretation, like the valued policy limit statutes, which mandate full payment for total losses from covered perils but may not apply to flood exclusions. The decision aligns with post-Hurricane Ian litigation trends in Florida, emphasizing efficient resolution of coverage disputes without redundant equitable remedies. In my opinion, the insurer, proving it maintained an incompetent claim staff and alleged it erroneously paid $320,222.32 more than it owed. Its attempt to get its mistaken payment back from the insured failed when Judge Chappell found the payments were made under the terms of the contract of insurance. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about these blogs and these videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a small fee subscribing to my Substack publications. Thank you for your attention.